Good morning, everybody. Thank you for attending session 6 of our webinar series. We're happy to have everyone here today on this kind of warm day in Toronto. So today we're going to be talking about tips for securing cooperation from AV adjusters and common pitfalls and treatments and progress reports. We're going to try to stick to those topics. So if you have questions that are outside of those, feel free to email them to me afterwards and I will get them off to Darcy or Deanna, or you can connect with them directly. Our presenters today are Darcy and Deanna, who are both partners in the firm, and Lucy, who's going to be answering any of your questions and chats and interrupting Darcy and Deanna as need be. So feel free to use the chat function or the Q&A function to ask any questions. As you know, we're doing these every other week. So what we'll be doing is recording today's session for everyone who isn't able to make it. We'll be sending that to everybody, not Monday, but the following Monday, along with the invitation for the following presentation. And with that, I'm just going to pass it over to Darcy to get today's session started.
Hey, good morning, everyone. I'm going to be talking on tips on securing cooperation from accident benefit adjusters. I'm going to be speaking for about 8 minutes or so. I'm going to pass it over to Deanna. We're going to deal with any questions at the end. Deanna's got a separate topic. So before I talk about cooperation with AV adjusters, let's go back to why cooperation is important. Our goal is to help clients make a great recovery, and your goal is the same. And in my view, that's accomplished by helping clients access all of the treatment they need and reducing unnecessary stressors. That's what I can do in the context of ongoing rehab in the early stages following an accident. And the way those two goals are accomplished, helping clients access treatment and avoid stressors, is to get approval from the accident benefit adjuster and avoid IEs. And I highlight that second one, avoiding IEs. And why is it important to avoid IEs? IEs cause stress and upset to clients who get anxious for the upcoming event. It inconveniences and interferes with their treatment protocols and their routine. It results in notorious delays and scrutiny. And this is one that people don't appreciate. It handcuffs adjusters to be helpful. If you go to an IE and it says, no, it's not reasonable, they can't do anything. They have no flexibility left. It causes upset to the client and the team when it's denied. And even when it's approved, it delays matters by weeks. So that you have to avoid IEs. And the way I deal with cooperation from accident benefit adjusters is I try to humanize the process. I try to treat the adjuster as a team member. That means inviting them to participate. These are not mean people. They're suspicious. They're frugal at times. They're dealing with bureaucracy and red tape. And my job is to make them part of the team, treat them like a person, have them treat us, the team, the client as a person, somebody they're trying to help rather than stop them helping, and involve them. I invite them to team meetings in almost every case, except cases where the clients really aren't presentable and it would be difficult. But almost every case, I will invite the accident benefit adjuster to participate. The second thing is request approval for everything. Reach for the stars. You're all professionals. You're all very experienced. You all have good advice. Push the envelope, but do so while being mindful of the need to be reasonable. And that means dialoguing with adjusters. So if you're going to request everything, but if you're thinking of submitting something that you believe and have the foresight to know is going to be contentious, then dialogue with them. If you're going to send in a request for an expensive new computer, then call the adjuster saying, hey, I'm the OT, I'm recommending a computer, here are the reasons. Do you have any preliminary thoughts on that? That will set them up and significantly increase the chances of them accepting the plan without forcing it to an IE. So dialogue. And then the last resort is to use the lawyer as the muscle. So my plan is always ask for everything, dialogue with it so that it can be advanced in a way that you know will get approved. If it doesn't get approved, call them to work it out. If that doesn't happen, call me. If it's important to you, it's important to me, it's important to the client, I will get involved. I will write letters, I will push them around as much as I can, I will make persuasive arguments. I will explain that it's a non-cat case right now, but it's going to be catastrophic, and we're okay with them spending the money as we've set out, and I'd allow you to do it. I think that significantly increases the chances of getting cooperation. So those are the key points from my perspective. Include the team, the adjuster. I had invited adjusters to participate, but because of the red tape and bureaucracy, they were told they're not allowed to participate in a webinar sponsored by Thomson Rogers. But in that process, they said to me things like, the team thinks of us as the devil. They know we're going to deny things. They never call me. They ask for unreasonable things. They take unreasonable positions. And I said, well, what do you think of sort of my approach of including the team? They said they love that. They totally understand the issues. They're more likely to approve things. They can avoid IEs. They don't like IE things. They have red tape that requires them to do that. And the IEs are the biggest disaster. We see it on the attendant care issue all the time right now. Not everyone accesses outsourced attendant care and taps into the attendant care benefit. It's a merged fund, but they don't usually tap into the benefit these days. So when you get IEs or IE requests or a request for further attendant care quantifications, I try to get out of it. And I've had a lot of success. I write letters saying, look, they're not tapping into the attendant care. They're not doing it on an outsourced basis. We're not looking to you to pay outsourced attendant care. You really need to spend money. And I do that for multiple reasons. The most important of which is from a legal perspective, I don't want an IE that reduces that attendant care quantification because that IE goes to the tort defendant. Why would I want to let somebody else generate a report that's going to say the attendant care is less? So those are our thoughts on helping influence cooperation between the accident benefit adjuster, get approvals, to avoid conflict, and to make things run more smoothly for the long-term benefit of the client. I'm going to pass it over to Deanna, who may have something to enhance or to add to what I've just said. And she'll pass it back to me if I have any follow-up comments, and then we'll have questions at the end, and Deanna will have a topic.
Sure, I have a few additional tips actually. And Darcy, what you just said is a great segue to the first one that I had in mind. And by the way, good morning, everyone. Thanks for joining us on a otherwise very sunny Friday. My first tip is that read the IE reports and use the insurer's own evidence for your support. Sometimes there's things that we actually can agree on, and it's found right there in the IE report. So I generally assume that adjusters are very busy, and that when they're reading the IE reports, they really just go straight to that last page that has the conclusion sections. But they're missing a lot of meat on the bones, meaning contents in the body of the report. So read the IE reports and see whether there's, for example, any findings or observations in the physical examination section or otherwise in the body of the report that may not have actually been repeated in the conclusion section. So for example, you might have someone who concluded, well, the person doesn't need physiotherapy, but the IE report might reference repeatedly throughout it that the insured or our client was crying, was emotionally upset throughout. So maybe reference all of those citations when you're then putting in an OCF 18 for psychology or social work. Also, sometimes there's specific recommendations that an IE assessor will put in, but no one actually acts upon them. So the IE assessor might say, well, no, this person doesn't need attendant care, though they could use a long-handled reacher to help them since they've got issues with raising their arm above their shoulder. So then go ahead and fill out the OCF 18 to get the long-handled reacher. The other thing is sometimes the IE assessors, I find, put in hints. So, you know, a physiatrist, for example, again, might say the person was crying, they appeared to be in very low mood, but it's outside the scope of my expertise to comment on whether or not this person needs psychological counseling. That's a hint. That's a neon light saying this. Sorry about that. That's a hint that the person needs psychological counseling. So again, cite that saying, well, your expert didn't feel that they could comment on the need for psychological counseling, but they certainly reference things like low mood and crying and use that as in your OCF 18. The other thing is look for some other helpful things that are referenced in the IE report. Things like the fact that the person passed all of the validity tests, or the fact that there were repeated reference to the person putting in good effort. Sometimes IE experts note that the person does appear to be very motivated. So I try to use as much as I can some of the hints and the little goodies and nuggets we can get from IE reports, even if they're not contained on that last page where we see the conclusion. The other thing is to give the adjuster a reason to change his or her mind. So for example, you might have a change in life circumstances. Maybe psychological counseling wasn't approved before, but maybe now that the person is returning to work and they're feeling overwhelmed and they're trying to manage more things at once, that's a life circumstance that would give a reason for a change. Other life changes are whether the person's starting a new school when we're talking about minors. As we know, for a lot of us lately, COVID-19 has been, I found, a very successful life change that's allowed for some adjusters, certainly in files I've had, to reconsider previous denials or reconsider whether or not they're even going to ask for an IE. Sometimes you might also have a change in medical circumstances. You know, in some fracture cases, it takes time for arthritis to develop. And when it does, that's a real important change. It's a really important change. There might be surgery. There might be a late diagnosis. Someone may have suffered a fall as a result of their initial injury. So think about those differences that give the adjuster, if I may, a reason to save face, a reason to now approve something that may have been previously denied. The last thing I was thinking about, again, which is along the line of what Darcy has said, bringing the adjuster into the fold as a team members, focus on common goals. What are things that both your client and the adjuster would want to accomplish? So that's things like reducing costs. So maybe the adjuster is giving wind that they're not inclined to approve any more occupational therapy, but an RT would be a cheaper cost under supervision of an OT. So when you start to get wind that there may be a denial coming, try doing something like a cost-saving measure. So a social worker instead of a psychologist, an RT instead of a occupational therapist, a one-year gym membership rather than private personal training sessions. Another common goal is a return to work. So if the adjuster previously hadn't approved PT or had been denied a year ago, but your client is now in a position where they're really genuinely trying to go through a work hardening process, put together a multidisciplinary team and pose it as a work hardening team. And that can often be helpful because ultimately the adjuster may not want to pay an income replacement benefit forever. So again, it's a common goal that you have. Another common goal would be to avoid regression. So if physiotherapy, for example, isn't approved or it's going to be denied, then you might want to say, I'm concerned that this person's going to regress, and that will make it worse for the other things, the attendant care, the income replacement benefits. So if you're not going to approve PT, can you give us something that would still allow them to maintain the gains that they've made so far? Something like a yoga session, which would be cheaper. As I said, a gym membership, which is generally cheaper than PT. So my last tip is focus on the common goals, often which are cost associated, but which in the end still would get your client more treatment than he or she otherwise would be getting.
So I'm going to jump in again. It's Darcy. Before, just to follow up on a couple of points, Deanna raises some good points about common goals, especially when it comes to return to work. I always tell the adjusters, you're fine to deny it, but it's just going to increase the chances you're going to end up with a CAT claim because they're likely to deteriorate. And once they kind of get that gist, they sort of come around often. There are a couple questions that I'll try to address quickly. Michelle was asking about changing IE assessors when you get an IE notice. There's not much that can be done. I usually send a letter, a warning letter saying, you have chosen this assessor, they have a reputation, it has to be a legitimate bad reputation. And I usually quote something from a judge or otherwise. You do that at your own peril. I will be relying on this letter. You may wish to change. And usually when you send that, you make a call saying, you sure you want to use this person? They will come around and switch it up where possible. I think that's it. Lucy, you see any questions we should address now?
Yeah, there's another question here. For denied treatment plans, who would be the best person to talk to the adjuster about the denial? The provider that submitted the treatment plan or the case manager?
So I see it as a hierarchy. I always start with the provider. The provider should call the adjuster, work it out. Next in line is the case manager, or this case manager on the file. If they have more experience or understanding of how everything merges together in terms of a rehab perspective, have the case manager call, and then get me involved as the muscle. I'll come in, I will do whatever I can to make sure that the team's recommendations are adopted. I suggest we go to the second topic. I'll pass it back over to Deanna to deal with her topic on pitfalls.
Sure, so I'm going to talk about report drafting, and obviously we're trying to focus on accident benefit claims, so this will often come up in the context of your progress reports or treating reports. That being said, a lot of these tips are relevant to the tort claim, and on that note, actually the first tip that I have is not really an accident benefit tip per se. It's really a tip for tort cases, but the reason why we're discussing it in this context is that to the extent you don't realize it, the accident benefit file in its full and complete form has to be produced in the tort case, and quite often, as you know, we usually have both tort and accident benefit cases ongoing. So what you give to the accident benefit insurer is ultimately going to be seen by the eyes of the tort defense lawyer. So the first tip is, and this was somewhat of a pet peeve that Darcy and Lucy and I all discussed that we shared, is including too much detail about liability, meaning about how the accident occurred. Keep in mind that accident benefits are otherwise known as no-fault benefits. So whether your client is at fault or not is for the most part irrelevant to an accident benefit claim. You just need to show that there was an automobile accident that occurred. So when you're doing that, please try to give the least amount of detail that's necessary. And that's simply because often liability can be contentious in the tort case. And so we don't want to provide unnecessary detail. What can happen is that our client might end up being cross-examined or questioned about it at the tort examination for discovery. So you really don't want to provide those details anytime in advance. So I'll give you an example of what we're talking about. Let's say you have a head-on collision. Our client's driving along, the other driver came into her lane and struck her head on. What you want to do is just say the client was involved in an automobile accident where she was struck head-on by an oncoming motorist. You've established she was involved in an automobile accident. For accident benefit purposes, that's all you need. You haven't given away any unnecessary details that might actually be contentious in the tort case. We usually have a trifecta in tort cases, meaning speed, distance, time. Those are often very contentious issues, as well as whether or not the client had the opportunity to avoid the crash. So putting in an entire paragraph in a progress report saying something like, the client was driving, she had her daughter in the car, they were having a conversation, and next thing she knew, all of a sudden, a driver was coming at her at 60 kilometers per hour, and she tried to turn towards the left right after she braked. So as you can see, I'm going on and on, but you'd be surprised, we see this a lot in progress reports, and it's not relevant to the accident benefit case, and it could actually hurt the client in the tort case. The only exceptions that I would say might apply would be if it actually is relevant to your opinion, then of course you have to put it in. So for example, when you see things like a small impact, if you're a physiatrist or a physiotherapist, something like that, you might want to explain that even a small impact can still affect what may have been a previously asymptomatic but existing degenerative condition. So we know a lot of people when they're older have degenerative back changes, but they don't even know it's asymptomatic. But even a small impact can then trigger that. So that's when you might want to explain an impact. Similarly, if you're a psychologist or a registered social worker, then it might be relevant to discuss some of these circumstances, the traumatic circumstances around the crash. Not so much how many seconds it was or what speed it was, but you might want to explain the vehicle spun, the client was trapped inside the car, the client had her daughter inside the car who was screaming. Those things certainly can be relevant, I would imagine, to your opinion, but just please try to keep the details to what is actually necessary to convey your opinion. The second tip is to avoid what we call absolute words. These are words that just have no wiggle room. Words like never, can't, everything, nothing, always, don't. There's just no give with these things. And the issue is that when we speak colloquially with one another, often we'll say, oh, I can't do that. That's not really what you mean. You don't really mean I am incapable under any circumstances on any day of doing X. Colloquially, that's what we say, when what we really mean is I have difficulty doing something. So the problem with that, again, is a credibility issue, is that if you're reporting that someone can't do something, she can't lift anything, and then she goes to an IE or he goes to an IE where he or she does lift something, then there's an inconsistency and it becomes a credibility issue. As well, from a tort standpoint, as I said, since these reports are produced in the tort case, we always have to be worried about what surveillance might come at some point. So better to use words that have some cushion, have some wiggle room. So these are words like, rather than saying never, how about rarely? Rather than saying always, you can say typically or usually. Also, rather than saying can't, and I know that can't is one that people often can't avoid, I try to tell people never let can't float out there on its own. It's probably not that someone can't do it, but that there's restrictions. So they can't for long. They can't repetitively. They can't at heavier weights. They can't without feeling pain the next day. So please try to give some wiggle room to avoid any inconsistent inconsistent statements, or potentially some sort of risk with surveillance down the line. The third tip that I had is, from our standpoint, often what we do with your reports as the lawyers is we quote them. We quote them to judges at pretrial conferences. We quote them in mediation memos. And when I am quoting something, what I really want to see is a quote from the assessor's opinion. So please, the tip is focus on the objective rather than the subjective. I certainly appreciate, I know absolutely, so you don't have to worry. We know you have to include some subjective things. We know you have to write what the client reports to you. But if you can, focus more heavily on what you observe. I don't need a healthcare practitioner to tell me what someone has reported in terms of what I'm citing in a mediation memorandum or in a pretrial memo. I really want to know what the assessor has observed. So where you do have to cite what the client reported, it's so helpful when you can add your own objective observations to corroborate that. So for example, you can say the client reports that they feel fatigued throughout the day. You might say, that's consistent with my observations from this assessment. I assessed the client for an hour, and as the hour progressed, I noticed more yawning, more head down. I found that I had to repeat myself more often as it appeared that the client was losing focus. So now, while you have reported the subjective, you've bolstered it and you've supported it with your own objective impressions. The fourth tip that I have, and I've just got this one and one more to go, and I'll pass it back to Darcy. The fourth tip is to try overselling. The same way that it's funny that Darcy reported that some adjusters feel that team members think that they're the devil. I think that some adjusters might think that treatment providers are advocates. And so you want to always maintain your own credibility, because it's sometimes more persuasive to be objective and neutral rather than to act as an advocate. So things like acknowledge pre-existing history. You don't need to pretend it didn't exist. What you want to do is explain how it's qualitatively or quantitatively different now that the accident has occurred. Or you might want to explain how it is or isn't relevant to your opinion. So for example, if there's a pre-existing history of psychological dysfunction and there's a post-accident history as well, you might want to talk about how this was someone who was susceptible, more susceptible than your average Joe, to having a stronger impact from the accident. You might want to talk about how it isn't relevant, or how it's different. So for example, you might want to say, despite this history, and acknowledge whatever that pre-existing history is. You might then note that prior to the accident, the person was still able to work, whereas they're not now. The person, although they had that history, wasn't taking any prescription medications, wasn't receiving any treatment, was able to still multitask between work and caring for the family and taking care of the home. So again, you just want to explain, don't hide or shy away from the pre-existing history. Use it actually to bolster your opinion, and use it to show that you're a credible and objective assessor. And the other thing is try not to throw out bald statements. So rather than just saying something like, the person was in excellent health prior to the accident, give it a bit more meat. Show that it's not just a bald statement you're throwing out, saying, I've reviewed the OHIP summary and I've reviewed the family doctor's records for 3 years prior to the accident. From what I've read, I don't see any health records, any health issues that were serious, that required referrals, that required medication treatment. So in other words, try not to throw out just a bold statement, but rather give a little bit of rationale to what you're saying. And the other thing is acknowledge gains. Of course, adjusters are not going to want to keep approving things if there isn't actually any help that's being demonstrated. So acknowledge gains, but then talk about how it's a staged process. You know, we see this often with psychological counseling. They first have to be able to talk about the crash before you can then get to what's upsetting them about the crash or whatever the case may be. So talk about a staged process so you can acknowledge you've successfully passed stage 1 and explain what stages 2 and 3 and 4 would look like. The last tip I have is to try to focus on the big picture. I absolutely appreciate that for a lot of you with your college guidelines, there's certain tests you're required to do or to comment upon. But for myself, when I read, for example, an OT report, sorry to pick on you guys. When I read an OT report and it's a case involving an ankle fracture, and the first 5 pages are dedicated to hand grip strength testing and range of motion testing of the right shoulder, I'm starting to lose interest in the report. What we really want to try to do is focus on what the big picture is. What's this case about? And even if for some reason you feel it's necessary or college requires you to do so, to involve all these other things, try to even within your report, make it chronologically so that the really important issues come first and that they're repeated in a summary section so that we can actually focus on what the real issue is at hand. Darcy, I don't know if you've got any follow-up from that.
Well, I'd like to tie the 2 issues a little bit together. And the one thing, those are good tips on report writing. When it comes to treatment plans, many of you have practices of attaching some kind of comments, reports, otherwise, to increase the probability of acceptance, which is a great idea and it's good practice. What you can do in those reports, what I would recommend is adding a consequence of denial issue. Because if you write in your report, we're advocating, we recommend 12 sessions of massage therapy. Without massage therapy, this person may deteriorate and have more mobility needs. That changes the dynamics a little bit. So I'd like everyone to think about whether they can include a sentence about consequences of denial. I think that would go a long way. It would help me. I would understand that's the first thing I'd say. They've already put in their paper. Without that, they're going to have mobility issues. Your attendant care is going to go up. Is that what you want? So that will be my only comment. And perhaps Lucy can now raise any questions.
Yes, we have one question here. This, Deanna, goes to a bit about what you were speaking to for reports. So I noticed that there are multiple truths. For example, clients report loss of consciousness and other records don't support this. What truth would I accept or report?
So going back to the first tip I made, first of all, is the loss of consciousness relevant to your opinion? If you're a physiotherapist, and you're treating you're there to treat the physical injuries that the client suffered, I wouldn't reference it at all. Now, it's different if you're a neuropsychologist. One thing you should do is probe the client when you meet with them. Sometimes there's a misunderstanding I find with our clients between a loss of consciousness versus feeling shocked and feeling confused about time or missing time. And so I understand that concern because I see those inconsistent statements too. And sometimes I think we want to avoid the term loss of consciousness. Can you smooth it out or soften that by saying there's a period of time that the client doesn't recall? That doesn't necessarily mean that they didn't lose consciousness. It doesn't mean they did. It might be that they were in such a state of psychological shock that they can't recall it. So my tip is don't include any reference to it unless it's absolutely relevant and necessary your opinion. If you do have to include it and you've noticed these inconsistent statements, try to avoid the term loss of consciousness. Focus more on the fact. The fact is that the client has periods of time that they don't recall.
Thanks, Deanna. I don't see any other questions, and I see that Mark's here, which means we've hit the 30-minute mark. So if anybody has any questions, feel free to ask them now. Otherwise, I think we have an opportunity where we can ask the question, answer questions after. Is that right, Mark? Through the, oh, Mark, you're on mute.
Feel free, you can send the questions to me or any of the panel members, and they'll be happy to answer them for you. We did have a few people ask about the slides. They will be available not Monday, but the following Monday when we send out our next current events session. We'll also have a link to the video, and if any other questions come in, we'll answer those at that time. The next current events webinar is going to take place on Friday, July 24th, and we're going to have David McDonald, Robert Ben, and Stephen Berman presenting that day. Details on that to follow. If there's no other questions though today, I want to thank everybody for joining us and hope everyone has a great weekend.
Have a great weekend, everyone.
Thank you.